The gentleman from Florida, Mr. Posey, is now recognized for 5 minutes.
Thank you very much, Mr. Chairman. Most citizens believe that we make all the federal laws, that all the federal laws on the books are passed by Congress. But most people in this room realize that for every law we pass, there's probably 1,000 laws that are made by unelected, unrecallable, oftentimes unaccountable bureaucrats. They're supposed to make rules and that are enforceable as laws, specifically at the direction of Congress. But Congress has abdicated its responsibility to control the rulemaking process. So the odds are, if you're called into court now on a federal violation, it's probably 1,000 to 1 odds it's against a rule enforceable as a law that some unelected bureaucrat made. When Director Kraninger, former Director Kraninger, the FPB, appeared before us on her first semi-annual report in 2019, I asked her about whether the CFPB should conduct cost-benefit analysis on its regulations. She expressed her strong support of the idea, and she held a Bureau symposium on cost-benefit analysis in 2020. Apparently, little progress was made on that front after 2020 under Director Chopra, so I'm pleased that we have 2 bills for this hearing that would institutionalize a culture of cost-benefit analysis at the CFPB. Mr. Watkins, briefly, could you explain how cost-benefit analyses could be used to improve rulemaking at the CFPB?
Sure. So as cost-benefit analysis, we look to the benefits and the harms of every rule. We try to evaluate in detail all of the various benefits and all the various harms. And if you look at that in detail, you can find areas where the harms outweigh the benefits. And so by relieving the pressure on those areas, by either not issuing rules or issuing less stringent rules, we can make the rules provide more benefits to the American consumer and at the same time cause less harm. It may be better to create a slightly less stringent rule that provides the same benefits and yet allows the industry to have more money to give to consumers or to not cost consumers as much.
Thank you. And I can't understand why they wouldn't do that, other than it's been my experience with CFPB. They're the most arrogant, petulant, and defiant agency that I've ever dealt with. Mr. Hempler, the current management of the CFPB believes that many or most of the fees and financial institutions charge are junk fees and merely made up. I don't want to call that junk regulation, but it's tempting. Please explain how many or why even most so-called junk fees represent a legitimate reflection of the economic opportunity cost of the funds tied up in the consumer credit when consumers pay late.
Thank you, Congressman. It's great to see you this morning. Essentially, the press release that the Bureau issued on junk fees, one, it goes beyond its authority to address resort fees, ticket fees, well beyond anything in the financial services arena to begin with. There's no definition of what they're talking about, and it has a chilling effect on our member companies, both depository institutions and finance companies, in terms of wanting to stay within the guardrails of what our regulator expects of us without knowing what those rules are. It's kind of like trying to figure out what the speed limit is without the sign being posted, but still held accountable. The Attorney General talked about accountability or institutions not wanting accountability. What we're trying to do here is figure out what the rules of the road are so that we can be good corporate citizens. We want to stand shoulder to shoulder with the CFPB in its mission to protect consumers. But I think the best way to protect consumers is to protect access to credit. And the best way to protect access to credit is to have clearly defined terms and conditions that both industry and the regulatory community can understand and follow.
Under Section 1022D of Dodd-Frank Act, the Bureau is required to produce a report on an assessment of each significant rule or order adopted by the CFPB under federal consumer financial law. The review is to be completed 5 years after each significant rule and is to be subject to public comment. Finding such reviews is hard. Ironically, there's an assessment that was posted on March 3rd for the Mortgage Disclosure Rule Act, which CFPB says was not a significant rule under the Act. Mr. Hempler, can you please comment on how well the CFPB is complying with Section 1022D?
With respect to the rules, I think where I would start with is actually finding the rules that the Bureau comes forward
Laws,
with.
yeah.
The regulations. These pronouncements that they put forward without giving industry any opportunity to provide notice or comment means that they're really not well informed in terms of how they're implemented.
Thank you very much. Thank you, Mr. Chairman.